when I walk into the mediation, I want to be set up for success. I want to have an idea of maybe kind of an idea where it will settle at. So I just know for me in my process, I need to roll up my shirt sleeves and put in that effort.
Howdy, and welcome to the show. Cooper's Code focuses on legal issues and noble practitioners, distilling wisdom so we all achieve the best results for our clients. I'm Miles Cooper, and I'm very excited to share part 3 of this conversation with Debra Bogaards. As somebody who has been a participant in your mediation process, and I'll call it a process because one of the things that is very clear working with you is you do a lot of prep work in advance. I will say you probably do more prep work and more efforts to make sure that the work's been done and the right people are in the room. Otherwise, the mediation doesn't happen. It's a statement, but it's also a question. Why is that your approach? How did you learn it? And how do you feel that that is effective?
Organically, just kind of like I did for trial prep. I'd always have to be prepared, or for a depo. I used to like retaining mediators who had subject matter expertise. And so I started out my mediations doing probably primarily personal injury, wrongful death, and employment. Have since expanded to other areas. But what can I offer? Well, when I get a mediation brief, I can review and will review excerpts or the entire deposition transcript, medical records, reports. If it's non-personal injury, I can be reviewing employment records or other product liability documentation. And so I review that to get ready to talk to counsel, because sometimes this is near trial. I think in November, I must have had 8 that got put on my calendar last minute because they had trial dates before the end of the year. So for 2 years, presumably, people have been working on these cases. And so I love it. It's like getting a case transferred right before trial. It's great. All the hard work's been done. And now you get to give it a bird's eye view and read everything that's important. And by doing it in advance, when I then talk to counsel on the phone, I can say, hey, some homework. I'd really like to see that deposition because it's interesting. It's been viewed 2 different ways from the same statement. So I'd really like to see the transcript itself. Or can you get me that medical record? It seems to be an important one date, and I'd like to give it some fresh eyes. So I can request certain documentation. There might be even documentation that the one side or the other has been trying to get for a long time, but once I have the magic as a mediator, I'll get it. So I want to make sure that everybody's on the right page to get it done. Should it be put over, which I did. I put one products liability case over because it was clear that they hadn't exchanged enough information yet. Because when I walk into the mediation, I want to be set up for success. I want to have an idea of maybe kind of an idea where it will settle at. So I just know for me in my process, I need to roll up my shirt sleeves and put in that effort.
Do you feel that there is a time and a place for in-person versus Zoom mediation? And part of the reason I'm asking is because it seems like everyone has gone to Zoom for the most part.
I'd love to be 100% back in person, but I'll take a few a month. I think you're right. I think most of the time, mediation by Zoom is equally effective. Claims reps love it. They're never going to give that up. So I have to be content with hybrid mediation sometimes. There are certain times where I do believe you should be in person still. And those kind of cases might be an employment case where an apology might be needed, or I'm going to get 2 different factual scenarios as to what happened, for example, in a sexual harassment suit. If the people are right there, it makes it a lot easier to be running real time. Other cases, it's very helpful for the plaintiff's counsel to be in person because I'm thinking of one wrongful death case involving the railroad. The clients from the plaintiff's side would walk to the kitchen, thinking of our Oakland office from ADR Services, very vast, beautiful office, but you have a long walk from one end to the other to go to the kitchen to get bagels. I always have bagels and cream cheese in the morning with them because I like people to schmooze and break bread. Well, as they're walking by the defense room so much, the defense, they will meet them, but they don't even really need to. They see that they are, very loving looks like accomplished. One was in the Army, the other is a bus driver, but dressed up. Very accomplished people, and they got a very favorable impression. What I need as a mediator is to sell that impression. One thing that doesn't come from the documentation is the mediator's view of how wonderful the plaintiffs are. So that's an example where in-person helped. I have another one that was in person. The defense wanted it, and they had their room filled with two different carriers and people. Plaintiff's counsel obliged, and she came to the office. Well, it helped her client. Her client was a very attractive woman, and she was claiming that she had a limp. Well, I talked to the defense and I said, there's glass offices here. I will bet you that at a certain point in the afternoon, when we just see her walk by to go use the restroom or get something to drink, she probably will have a limp. It doesn't mean she has it all day. Sure enough, at about 3:00, she walked by and we all noticed the beginning of a limp, because that's the way it naturally happens. And so that helped me get higher value in that case from a lot of skeptical claims reps. So there are good times to have them, but I, as a human being, just get nourished by the in-person contact. I also feel that it's good for plaintiff and defense counsel because you're in this for the long run. You need to establish those long-term relationships. So when you are together, that can happen.
Do you feel that there is a benefit in some cases to having a female mediator versus a male mediator? And if so, why would somebody consider that?
It's a great question. And I don't even know that I'm starting to reflect on the answer of that, but I know that I carry myself out as a mediator. So sometimes I don't notice the differences by being female, but I do know that in employment cases, oftentimes people will want to come to a female mediator if their client is female, particularly in a sex harass case, or I'm doing more and more sex abuse cases. Having a female mediator talking to a female client somehow makes them more at ease and comfortable. So I think it could be case dependent, but overall, I'll just use myself as an example. I was a hard-ass defense counsel to some. I empathetic on the plaintiff side. However, I'm also a grandmother now of 3, or a bubala. So women are usually very conversant and fluid, make great trial attorneys. And then the empathy that I can bring into it is very helpful on the plaintiff side when someone has injuries or they've wrongful death in the family and they're terrified of the process usually. I always ask people if they've slept well the night before in a mediation, and invariably someone has been terrified, but I can put them at ease. And so I don't know if that's necessarily by being a woman, but I have to think it could be some of the traits that I have. There's a certain warmth and empathy that are natural. And so I do believe that, at least for me, it's helpful. And there are less women in the mediation field than there should be. If you look at in our office, let's say an ADR in Oakland, you're going to see usually white men with gray hair or balding, and maybe you'll see a pop of a woman here and there. I think we're less than 5%, but I do think we're a strength.
When invariably in mediation, the parties hit impasse, do you have a favorite tool?
I have a toolbox.
Unpack it.
It depends on the case, obviously, but I've heard people say cavalierly, hope you never get to an impasse.
Oh, it happens in every case.
It happens. People, we attorneys, we can get stubborn. We can feel that our side is the right side. People don't walk out, by the way, of Zoom mediations. That's lovely. But people can get entrenched in their sides. Let's put it that way. And so I've learned a few things. Number one, the easiest tool is go outside, get some fresh air, take a break, get some food. That helps. 2, I've started using brackets on occasion. People usually recoil. I used to, but brackets sometimes are a sure way to get to that sweet spot a little faster. So in the right case, I will. And then I would say 99% of my cases settle through a mediator's proposal. And that is becoming more commonplace. I don't think it means that lawyers are lazy. I don't think it means that you don't have the skills as a mediator to resolve it otherwise. I really think it's a face-saving measure. Perhaps on the plaintiff side, the plaintiff and the attorney might not agree on the exact number. They might be having some trouble managing expectations. And by having a mediator who has been trusted, hopefully has built rapport with their client, say, this is the most that I think I can get the defense to reach. And I know it's less than you want, but you will end this case today. And that has great value. You've cut out the risk. You've cut out the emotional roller coaster of what's going to happen over the next few months and at trial. And so I think this is a good number. On the defense side, you may have a defense counsel who's stuck trying the case, but they think that number would be great, but they have a stubborn claims rep perhaps that doesn't want to pay it. Maybe it's above, which often happens to me, where it's above their settlement authority. So they have to go back to either their claims manager or maybe back to Bloomington to the headquarters and roundtable it. But now they get to add, the mediator that we selected, who 42 years did defense work, 38 jury trials, recommends this, then it works. I have only had my mediator's proposal from both sides of plaintiff's counsel once and defense side rejected. All the rest have been accepted. So we're talking hundreds. So I know the process works, and I've changed a little bit how I do my mediator's proposal. I used to tell, and I still tell people, it's the highest number I can get the defense to reach and the lowest amount you probably would want to take on the plaintiff side. But I'm really working on the defense to see how much money we can get. But I have started to kind of talk to people earlier on to kind of see where those numbers might be, right? So this is pretty funny. I was teaching my class last month, and someone we both know was there, and she was talking about an amazing settlement she got at mediation. And she said, at one point the mediator came to me because their number was $450,000 from the defense side and said, what do you think about $500,000? And I stopped and told the class, the mediator was trying to see with his plaintiff's counsel if that would be a good mediator's proposal. And our friend had like a light bulb moment, said, I didn't even think of that. But of course, so I think I'm starting to put my feelers out a little earlier on to figure out what that magic number will be.
I see that sometimes used as a tool to kind of sense things. I was going to follow up a little bit with you using brackets more frequently, because that to me is oftentimes the way a mediator is getting a sense of where, if you're doing a mediator's proposal, I know you're telegraphing the midpoint, and I know there's some cushion too. So the use of a bracket from both sides to help kind of target where your mediator's proposal might land.
Right. Yeah, but every mediator has their own secret sauce or magic, right? And how they get the case settled. And I don't know that I can necessarily analyze mine and tell you what exactly did it. But sometimes now I can feel, whether it's early on and it just takes the parties longer to get there. Some people need to do, we call it tit for tat negotiation, where I've also called it the dance. Another judge calls it the haggle waggle. But, you have to go back a little bit. And I heard one plaintiff's counsel tell me at a seminar that he won't go to a mediator who doesn't settle it within 3 moves.
Fascinating.
And I thought about it. I said, well, not every case and not every attorney would want that. Sometimes I can do it in 3 moves, but the attorneys need to do more of the dance. So I think it's really dependent upon what the style is of that attorney. I have some attorneys that love to do the tit for tat negotiation because they feel like you're on the beach and you have that long rope and you're playing tug of war. And they feel like if you just pull, I might end up with a number for them that's over the median or the mean versus the other way. So they love seeing that every time. And we've heard of deal fatigue when it's too late in the day, but they don't care. They want to play that out. Other attorneys want to do it in 3 moves. I have yet other attorneys, employment defense counsel, close friend, who, if he has a full day scheduled, he won't let me settle it before 3:00 because he feels with deal fatigue, he's going to wear down the plaintiff, which does happen. That's why as a mediator, I'll go into the room with the plaintiff and say, you know what, could you do me a favor? Would you mind going outside? Just take a walk around the block, get some fresh air. It's late in the afternoon because I don't want that. I want everybody to be fresh when they're making their decisions. So yeah, everybody's got a style.
One thing that came up when we were at a seminar within the last year, a couple different lawyers talked about how I don't mediate my good cases. In fact, if they ask for mediation, I tell them, no, we're going to trial. How do you, as a professional in the realm of resolving cases and knowing that 98% of cases settle, and by the way, the people who are saying this are very talented trial lawyers. How do you respond to that kind of a philosophy for a trial lawyer?
I think a good trial lawyer, a great trial lawyer, would always go to a mediation. You'd be a fool not to, right? You're so cocky, you're not going to go see what the case would have settled for. A mediation is voluntary. It only takes 4 hours, half day, 8 hours, full day, or any time in between. It gives you a time when everyone focuses on the file. You've got everyone in claims and you can get up to headquarters, right, to focus on getting your case settled. That's so special. We don't have CMCs or case management conferences anymore where people appear in person. And we used to sit outside with counsel and get some coffee and talk about their case. We don't do that anymore. So why would you pass up an opportunity for in one day to see if you could get it settled? Oftentimes, the defense knows of its problems. They're not stupid. There's some excellent attorneys. They know of their weaknesses. They know of the problems. They know that they have to unload a case. And so they may be able to do so at mediation. Maybe they need the mediator to help them persuade claims to see otherwise because they don't really want to try it. And that has happened with me. So, you know, you and I have had cases too where you go to mediation, but you want to stay at policy. And as long as you are communicating that to the mediator, you know, let's take one of those attorneys, you said one of the top tier attorneys who says, I just go to trial. And again, I think they're doing their client a disservice.
I'll be clear on I don't go to mediation on my good cases.
Oh, my good cases, right? Yeah, sorry. So let's say they say that. I always kept a really good eye on my costs on my plaintiff's cases, because if you have a smaller case, you can't run up that much in cost if they can't get it. I always wanted my fees to be less than what they took home, right? And they could have a high medical lien. So on their good cases, you still don't want to run up those costs if you don't need to. You don't want to put your client through the emotional trauma, which it's there. They worry about it. This is what, you know, you and I love to do as trial attorneys, as mediators. We eat this up. You know, I used to say all this in a paycheck too, but not for our clients. So if you care about your clients, I would say spend a day, see if on your good case, you could get that policy limits demand now. And if you can't, then I understand why you go to trial. Or if you're really polarized, you go to trial. But I work with one attorney that we both know in common, plaintiff's counsel. And she said she would never go to mediation because they never, you know, put up real money and she didn't do well. And now she gives me a few a month and we do settle them. So I would say there's nothing to lose at a mediation.
If you're enjoying what we're doing here with Cooper's Code, please help us extend our reach by giving us a 5-star review on Apple Podcasts. And consider sharing an episode with a friend. Additionally, we want to know who you want to hear on the show. Have an interview suggestion? Email us at podcast@coopers.law. So one area that I know can sometimes be a challenging issue for mediators is when you know that the plaintiff is willing to take a number and the defense is actually willing to pay even more than that, and you're in both rooms. How do you handle that situation?
I just thought of a fancy term for it as ZOPA, Zone of Potential Agreement, where they then overlap.
Perfect.
And that does happen more often than you think. So it just depends on your individual mediator. But if I know that, I'm usually trying to get the most I can for the plaintiff. So if I know, for your example, that the defense is willing to pay up to $800 and that the plaintiff's bottom line is $600, what do I do with that $200,000 delta V? Sometimes I will do a mediator's proposal. I think that's the easiest way to handle that. And it might be closer to the defense number. So that's one way that you can handle it. I had a newer attorney at a mediation she got within 2 weeks of joining a certain firm, plaintiff's counsel. And she came and she was negotiating, and it was kind of newer for her, the negotiating style. It was kind of like, I've taught my students, you put out your number that you anchor pretty high that passes the giggle test. And then you should have a goal and you should have a bottom line. So we were negotiating class, they put out their anchor, and then their next move was their bottom line. So this attorney was kind of like that. She was way up high, and then she came to me and she says, okay, this is really what I want. And I looked at her and I said, okay. And I rounded pretty far up for her. Went to defense room, got it. We were done.
We've talked a lot about tools and toolboxes and other things related to mediation. Is there anything else about your mediation practice, kind of your unique approach, that you would like to bring forward?
Part of what I bring, because I did 42 years, mostly on the defense side, then plaintiff side, and then decided to close the practice and devote myself to mediation for my last chapter, is I bring a wealth of knowledge of how things are done on the defense side. So for example, I had a case where a young man was riding his bike dark at night, and he was hit by someone coming home from the gym in his car. And the driver left, continued home, took a shower, washed his hair, and then went to the police. Yeah.
That's not a good fact pattern.
I get these facts at mediation. I think he only had 100 policy. So obviously he's going to be looked at for some extra contractual. So when I did my pre-mediation phone call with the defense attorney, who fortunately I do a few cases a month with, so we've already built a rapport, he can trust me. And I said, well, are you bringing him, is he bringing personal counsel to the mediation? He said, no. I said, can you hire him a bankruptcy attorney? And he said, well, I said, I used to do defense work. I know for an hour of the time, they'll usually pay for that. So we got that so that when it was set up for the mediation itself, he had an hour of time with the bankruptcy attorney to tell him, you should be putting up X amount. It still didn't work, by the way. So this gentleman had fled to India, where he was from, and it was a little bit of a mess. He had a messy divorce happening, other things, but he still needed to give money out of pocket, significant money out of pocket. So we set up a Zoom for like 6 a.m., which would coincide with his time in India, so I could talk to him directly. And then after that, we were able to get his extra contractual money. So understanding how it works on both sides is really important. And you talked about the work I'll do in advance to set it up for success. That was one example. Another example would be understanding apportionment and multiple defendants and coverage. So I had one case that had very nice plaintiff's counsel. He had a good case. He'd gone to mediation 2 different times with the same mediator and got nowhere. So then everyone agreed to me as a mediator. And I realized through my pre-mediation phone calls, I've got 4 different defense counsel and coverage counsel, yet they have not figured out apportionment amongst themselves. And you're this close to trial. And so when the day arrived, I had, motions for summary judgment they had submitted to me. I had these beautifully written briefs. And I went into the defense into the same room and I said, okay, I want you to give me your apportionment for all 4. They'd give me, they were 10%, 30% and so forth. And so I took everybody's numbers. I crossed off their self-serving numbers themselves, kind of added up, and I came out with what would be the apportionment. And I told them, and all of them accepted it.
Wow.
And they all wanted to talk to me, by the way, and tell me their size. And I said, I'm not going to listen to anybody because you've already done that for 2 full days. I've already looked at your motions for summary judgment, your briefs. So I kind of have an idea of your case. Then I said, okay, let's invert. So invert is when you ask what the other side is going to need to say yes. We all get so vested, don't we, into what we want on our side. But we're not thinking, what's the other side going to do? So I asked them to give me a settlement range that they thought the plaintiff's counsel was looking for. So they did that. And then it was really easy. Within, I think it took about 4 or 5 hours for all of this, got the case settled. So again, just using some, I think, experience. We've seen these patterns all the time. It's easy for me to deal with apportionment numbers with coverage. I've had a year of coverage. And so I have another case coming up, habitability, that's 50 units. And I've already handled 30 units for them. So I know what some of the issues are. So until we get to the 4 different days of mediation, over the past few months, I've been holding like a discovery referee, maybe check-in Zooms for 1 hour each, so we can make sure that plaintiff's counsel has what he needs, that he's getting the defense what they need. He's adding more plaintiffs. When does that stop? They're doing testimonials from each unit. So I'm kind of orchestrating it so that when we finally have the first day mediation, again, we can be successful. So have that. Another thing that I do that's probably unique, I try to get the defense to send to the plaintiff's counsel a settlement and release agreement in draft form. In it, I ask them to put any special terms. Is there confidentiality? Is there liquidated damages? Is there non-disparagement clause? Whatever special clauses they have, so that plaintiff's counsel has an opportunity to make any revisions during the day. And then, presuming when we get it settled, I can have my staff at ADR Services, who are wonderful, do a DocuSign. And so by the time the day is done, the carrier has a copy of the settlement and release agreement, right, in their file, and they have a closed file. From the plaintiff side, the attorney doesn't have to get hold of his client. He's got that done, or she's got that done as well. And so we're signed, sealed, delivered in one day. So those are some of the kind of tips or tricks that I've been kind of developing or working on. And then, of course, we talked about in person. And so I started doing a signature Scotch tasting for those who like it afterwards, of like 3 single malt Scotches. And I remember I have either plaintiff's counsel or defense counsel say, "What? We're drinking together?" I said, "Oh, absolutely. This is the way it should be. It should be civilized. You're going to see each other again." So it's been fantastic. They can meet, talk, and they will. One other thing about in person that I can do, same habitability case. It had been going on all day, so over 8 hours. People were exhausted. We came back the next day. Once I got snippy with the other, and I realized, the defense counsel needs more time. She's got 9 people on her screen, several coverage counsels, several defense counsels, property management company, landlord, and she needs more time, and they're getting upset in the other room. So I decided I'd get everybody lattes. At that time, my office was near Blue Bottle. And someone said, "Why are you wearing your stilettos? You've got flats. You can walk up the hill faster." I said, you assume I'm interested in speed on this. I am not. Or at the end of that day, I know one of the attorneys had tickets to go see Bruce Springsteen. And I said, "Nope, we'll get you there, but you're all going to come next door for," Vic says good martinis. "You're going to come next door for martini." And it was so important that they broke bread together, because both sides were frustrated with each other, maybe legitimately. But the plaintiff's counsel decided to forego his filing his motion for preference the next day, which he would have had granted. And we were able to wait 3 weeks to get the rest of the case, the day pick, settled. So lots of good things can happen if you are present, if you're enjoying it, if you're in person even.
What I'm hearing is kind of a through line is that while almost all cases go through some form of mediation, and they sometimes can look alike, that each one that you handle has a moment or moments where they need their own unique approach, walking slowly in stilettos as opposed to walking fast.
Exactly. They just take that little bit of a moment to figure out what's, you said impasse, right? We don't want to get to an impasse. They obviously need more time. They're frustrated. And that's when the walking slowly in stilettos came up. I had another case once where we had the defense counsel wanted to drive down from Sacramento to my office as a field trip. So that's why it was in person. And he wanted to bring this plastic barrier that had fallen over at the store onto the plaintiff. We didn't really need that. But what I think he really wanted was we all went to lunch afterwards, and we had plaintiff's counsel, defense counsel, really nice time. And the defense counsel brings up at lunch, oh, by the way, I forgot, we need confidentiality and non-disparagement. And because we were, having a nice time all together, I could easily say, that wasn't brought up before we concluded the mediation. So I think you might want to let that one go. And of course it did very nicely, but that's because we were having, building rapport, building long-term relationships.
And that repeat player piece, I think, is important and far more common up north than down south. I don't know how many of the Southern California cases because we've seen a lot Southern California lawyers
I have a lot
coming up here. And there are many of them who are very, very talented, and there's a different culture and a different approach. That's where I see a lot of the confidential briefs.
Very. I've had them show up in T-shirts, certain firm from LA, off of a certain amount of bravado, but I do a lot with LA attorneys.
But they're very expensive T-shirts.
I don't think they were. I somehow got on a San Diego trial lawyer listserv, so I'm seeing a lot of San Diego cases. But they are different. They tend to be different from Southern California. But there are a lot of plaintiffs' firms that have satellite offices up here.
We've ranged from kids as lawyers to plaintiffs' work to defense work, maritime work, mediation. I really want to thank you for taking the time to sit down. I really enjoyed our conversation, Deborah. Oh,
thank you, Miles. It's always a pleasure. You're so thought-provoking and thoughtful about this exercise, and I'm honored to have been a guest on your podcast. Thank you.
You're making me blush. Thank you. And thank you for listening today. Please email us at podcast@coopers.law with questions, comments, feedback, and suggestions for who we should have on the show. Like what you heard? Share us with a colleague and leave us a 5-star review on your podcast platform of choice. To all of you doing justice out there, happy hunting.